All right, that's a lot. All right. Good morning, lady. Good morning, my lords. The matter in front of you, I think it's pretty straightforward. The application to the court is leave to appeal the orders of Justice Vaughn Smith. And however, because of the rules of the court and the status of the claim, I think the court is under an obligation to dismiss it as an automatic measure, because the matter in front of the court, refiled by the claimant, is already settled matters which the appeals court has already ruled on, and the Supreme Court has already ruled on, and those rulings were never appealed. And in the instance where the Supreme Court ruled, Justice Beswick made it clear that the only action that was permitted by the defendants when she dismissed their claim in 2015 was to file an appeal. Yet no appeal was filed, and less than a month after the final judgment and clarification order, the 23rd, 24th December, or about there, my lord, they refiled the very same claim without the appeal. So, based on the civil procedure rules, and the law, it's a constitutional matter as well. The law tribunal can't review its own judgments in any matter. So that's an automatic contempt of the court orders. And based on that, when Capital One filed Mr. Graham, who is not just the attorney for Capital One, but Lorraine Gallagher, when they refiled that claim, my lord, that was in effect, literally spitting in the face of the court and saying, to heck with you, we're not going to appeal this, we're just going to refile it. So, my lord, it's an automatic dismissal because, for one, the Supreme Court cannot re-examine another Supreme Court judge ruling, and two, the appeals court had in fact said this matter should be dismissed. So that is an automatic dismissal. So rule point 2.7 or part 7 of the civil procedure rule says a court can deal with a matter where it's convenient to all the parties. All the parties are here properly represented, and so because of the status of that claim and the settled matters that have been ruled on the same issues, the court has a responsibility to dismiss it. Again, part 10 of the civil procedure rule and part 12, when looked at in combination, does have provisions there that says if the claim has no prospect of success, then it must be dismissed, and the court must make that as urgently as possible, which would be in keeping with part 1, dealing with a case justly and expeditiously, and also giving effect to the civil procedure rules, meaning every action that must be taken this morning, my lord, points directly that the first thing that this court needs to do is to dismiss the claim. So the second thing, my lord, is that once the claim is dismissed, obviously, on the basis of contempt of the court's orders, and it should be effective from the time this claim was filed, which is in January 2016, and it's subject to the poison fruit concept or theory. Anything that was improperly done or wrong or bad on the part of the claimant, resulting in any kind of orders, beneficial or other, and any action, is in fact subject to the poison fruit concept, meaning once the initial ruling was made or is made to dismiss the claim, then everything subsequent to the action to that ruling, any action taken subsequent to that action, the ruling by this court, is automatically annulled, dismissed, vacated. So On that front, my Lord, I'd leave the court to consider while I give further arguments as to why it must be dismissed, and there are constitutional issues. So, in short, the application is to deal with Justice Smith's ruling, my Lord, but there's a greater need or objective in that the court has a duty and a responsibility to not subject the court and its officers to res judicata, where a person keeps filing or refiling the very same claim, on the same issues, and to waste not only the claim's time but the court's resources, as was raised by Justice Phillip in the matter of Bartholomew Brown and Michelle Brown versus Jamaica National, where the court ruled that refiling the same issues was subject to dismissal because the court cannot review its own rulings. So case law supports the dismissal of this claim as well, my Lord, on the basis of res judicata. On the matter of the Constitution guarantees that this claim can go nowhere. It's unattainable for the claimants to even dream of winning anything here, because the Constitution states clearly that the matter that they file this claim and keep refiling the very same claim over and over is beyond their reach. And I'm surprised that the judges who have looked at this matter after it was dismissed have not raised the issue or pointed out to the claimants that the Constitution prevents this from happening. And I'll correct myself, my Lord. Justice G. Brown did raise it, did rule on it, and said directly to Mr. Graham. In fact, he asked Mr. Graham, who is in control of the property and has been in control of the property. Mr. Graham looked and said, Mr. Thorpe. And the judge went, saying, there you go, and said, it's possession that determines ownership. And since Mr. Thorpe has been in possession of the property since 2006, he can't be legally dispossessed of the property. So the ruling of Justice G. Brown did address it, but subsequent to that ruling, and even before, all the other judges ignored that salient issue, which cannot be overcome in any regard. So apart from the fact that the rules of the court states that this matter has to be kicked out, the fact that the courts rule that these people have no interest legally in any of the contracts or sales agreement that they're claiming on is the other ground. Matter of the Constitution, where the Constitution specifically states that no property of any description. This is from Chapter 3, Section 15 of the Jamaica Constitution under the Limitations Act, the Fundamental Charter of Fundamental Rights and Freedoms, my Lord and my ladies. It states clearly, no property of any description shall be compulsorily taken possession of, and no interest in or over property of any description. I mean, any description is important in this case, my Lord, and I'll clear that up shortly. Shall be compulsorily acquired except by or under the provisions of that law. That one, or A, prescribes the principle on which and the manner in which compensation therefore is to be determined and given, and B, secures to any party claiming an interest in or over such property a right of access to the court for the purpose of 1. Establishing such interest or right, determining the compensation, if any, 2. Enforcing the approvals. So, my lord, in terms of this clause in the Constitution, and I remind the court and the claimant that the Constitution represents the highest laws of the land, and no act of Parliament or ruling of the court or action by anyone can supersede a constitutional law. In the case of Parliament, only a referendum where 2/3 of the population, voting population, has voted in a referendum to make changes to the Constitution, it can be effective or legal. So the Constitution is saying, 1, and I go to B first, secures a place for persons claiming an interest in property for that claim or right to be determined. This court already determined that in 2012 when the appeals court ruled that they have no interest or connection to the claim, to the contract, to the property, the issues. So that role has been already fulfilled by the courts, and therefore their right under the Constitution has been, satisfied. Compensation. The defendants have not sought to sell their property, and the claimants have not sought to offer any kind of payment for the property, which means that no action can be taken to take the property from the present parties who have ownership. And we know they have ownership not only by virtue of the sales contract and transfer of that property to those parties, but subsequent to that initial transfer and that party being in possession and legal ownership of the property for more than 12 years. And then having those rights and interests legally transferred and documented, authenticated documentation is on record, showing that the owner, the titled owner of the property, which is Business Ventures and Solutions Inc., at the time, before it was withdrawn as an active corporation and no longer exists now, had actually transferred via a quitclaim deed as well as an asset sales agreement to other parties, which we have listed in our pleadings as the successors in interest. And those successors in interest have not only had me file or we file the authenticated documents in the court's records, but literally it's been attached to so many pleadings and affidavits that it's almost ridiculous, my lord, that none of the judges have been paying attention to those matters which are raised. And based on that constitutionality of the claim, there's no prospect of success in this matter, because the only basis that Capital One, Lauren Gallagher, the Alexander Burnham Trust, now Stephen Rapier, is claiming is that, somehow by some nefarious acts that they took in the US, they own the property on Queens Drive. Now, my lord, again, the Constitution stops that, because apart from the fact that the legal titled owner, Business Ventures and Solutions, took no measures to remove, evict, cancel my hold on the property or possession of the property for more than 15 years, means that I have standing and, in fact, the right to control that property under the Limitations Act, which I have filed in this court to also do. And it's on record in my counterclaim, which the claimants are in default of, and I'm asking the court this morning to enter judgment on the counterclaim, default judgment, because they have not responded to the counterclaim, which was filed from 2018. So again, the court will have to, it's automatic that the judgment be entered, and if the claimants have issues with the judgment, my lord, they have the proper procedure which they can follow, is to file an appeal to the court, this court, and have the court, in fact, if the appeals court, to file an appeal to the Privy Council in this instance, because the matter is in front of the appeals court, and properly in front of the appeals court. And again, it would be hard pressed for them to get leave to appeal, because their means to the claim, my lord or my lady, is fraud and fraudulent representation that is recorded in the courts locally and internationally. And the court certainly couldn't give an order that would allow somebody to appeal a matter that's based on established and proven fraud and contempt of the court's rules, the laws of the land, the Constitution. So there is no prospect of success for this claim to go forward from the constitutional perspective as well, my lord. So again, it's automatic dismissal. So the applications that were made and were properly in front of the court by virtue of the application process, but nothing else. And Justice V. Smith failed to take the opportunity to enforce or implement or put into effect the Part 1 of the Civil Procedure Rules, as well as Part 2.7, because when the matter was raised and Justice V. Smith was exposed to the fact that Capital One had filed several matters, and that the court had ruled on these very claims, Justice, and the fact that there was an undertaking given to cover damages, Justice Smith said he wasn't going to commingle issues. And I said, this is not commingling, because the claim that is in front of the court is directly built on a foundation of the dismissed claim. And everything that's written in there, the present claim, is also alleged in the other claim, and that was ruled on. So it must be relevant. And plus, the undertaking for payment of damages, one was given in the first claim, which we must refer to, because the nature of the undertaking given in the second claim is the same. So in order to prove to the court that this claim is subject to res judicata and the rulings of the previous, we must look at those undertakings. So when Justice V. Smith is going to say he doesn't want to commingle issues because of just a claim number or a claim filed at a different juncture in time, he erred, because as long as the matters are in fact related, and the defendant has raised the clause of res judicata, then it becomes a must for the court to have taken the time to review it. The judge ruled that he withdrew the injunction. We have no problems with the actual withdrawing of the injunction, Lord, but when that withdrawing of the injunction is setting the stage to say, well, we withdrew the injunction and therefore, and we own Business Ventures and Solutions, and we came to some agreement with Business Ventures and Solutions that no damage was done, is also fraudulent. To say we came to an arrangement with Business Ventures and Solutions to say no damage is done is fraud in itself, because Business Ventures and Solutions has, and the defendants have already proven that with expert witnesses appointed by the Supreme Court in 2013, I think, already proved that damage was done. But the statement itself is fraudulent. And then, so the illegality of that simply means that what they should have said was that we've come to some agreement with Business Ventures and Solutions that we're not going to pursue damages. But the fact that they're saying no damage was done was fraudulent. But the reason they did that, my lord, was if no damage was done to Business Ventures and Solutions, so how would the other parties claim damages? So damages was proven, and that's a fact. So the judge erred when he entertained it and entertained the structure of the argument on that basis. Because damage was done, that's proven. And if damage was done, Business Ventures and Solutions was entitled to damages. And the damages that were done included damages which started from the time the injunction, the first undertaking, was issued by Capital One, meaning the damages accrued over that period, and Business Ventures and Solutions, if it was in the ownership of the defendants at the time, during that period, before the so-called transfer of ownership to Alexander Burnham Trust, those damages would have accrued to the successors in interest of Business Ventures and Solutions by virtue of their ownership status. And we're talking about Business Ventures and Solutions of Florida, my lord. And I said, while it was in existence, because what the claimants have done, they went and reinstated another corporation, Business Ventures and Solutions Inc. in New York, and they're trying to make the argument, oh, it's the same corporation. No, my lord, it might be the same ownership, and it might be the same corporate entity and name, and the foreign corporation, which was filed in Florida, is operated and must be operated legally as it's an independent corporation, not the same. So what Business Ventures did in Florida was exclusive to that corporate entity, not Business Ventures and Solutions of New York. So which means Business Ventures and Solutions had no right, interest, or claim in the Florida corporation that was withdrawn and no longer exists. So, my lord, based on those facts and law, again, in my observation of the law and the rule and the previous rulings of this court and other courts, the court is put in a position of not only setting aside those orders, but dismissing the claim. And in fact bringing this matter to conclusion at this stage. And if the court is of the view that they can't dismiss the claim, even though we've asked for it to be dismissed, and remands it to the Supreme Court, the lower tribunal, then this court must also remand it with written instructions, my lord, so that when it gets to the law tribunal, the same game that was played on the 2010 claim when it was sent back, where files disappeared for years, judges kept giving extensions and injunctions that have no basis in fact or law, and dragged this thing on, and until now we're still dealing with the same issues, more than 12 years, and which affected my business personally, and the business of all those persons that were damaged, and their interests, their money, their lives, for more than 17 years. So, again, ludicrous as it was, there is no need for this court to allow this matter to proceed and waste the court's resources any longer. So, hence we've asked the court to grant a number of orders, instructions, and directives, so that the law tribunal knows it cannot allow this matter to be continued, suspended, continued, files disappeared, and caused the defendants more harm. And the other problem that's it has become evident with this matter, my lord, is that, and we've pointed it out, that Capital One's intent, based on all the logical movements and pleadings and actions taken, is not only to defraud the defendants of the property in Jamaica, where property in Jamaica is subject to the Jamaica Constitution, and the jurisdiction of this court, my lord, and not of any ruling from a U.S. court. But that said, one of the things that's evident, and we've filed into evidence, again, proof, or in our pleadings, that Capital One routinely practices defrauding their own clients. So what Capital One is doing, when it has not still proven to the court or anybody that they're not legal trustees, have assumed the position of legal trustees of the Alexander Burnham Trust, and pursue this action against the defendants, and in effect charge the Alexander Burnham Trust fees, which we assume are excessive fees, for their services, so that they can continue to defraud the trust itself, and over time. And then when they realized that they could also sweeten their pot, they decided to, let's keep filing these claims, no support, no appeals, nothing, because somebody promised them, and the only person that could promise them that is their attorney, that they could keep the matter alive in this court. And Capital One's attorneys aren't fools, my lord. They're not stupid. They're good attorneys. Well, they know the law, they know the courts, they know how it works. I should withdraw good attorneys, because a good attorney would not get involved with anything of this nature. But they've taken action that caused this matter to be dragged on. So can you imagine a trustee who's bilking or milking a trust having 12 years to carry out those actions, and then on top of that have their fraudulent action reward them further by defrauding people in Jamaica here of their property legally owned, and then selling it and taking that money and running. One of the bases of a trust or trustee, and the fundamental principle, is that if the trustee recognizes that a particular matter or business is going to affect the trust, where the trust is losing money and there's no chance of recovering that money, then to cease and desist, abandon. That has not happened for the simple reason that Capital One is profiting. And one of the mantras of a lot of U.S. corporations, and Capital One is one of the largest corporations in the United States, is that continue doing illegal actions if the profitability from those actions are more than the fees or cost or fines or penalties of carrying out that action. In short, if you're doing something wrong and it pays you well, if the cost of doing those actions, even though illegal, is less than the profits from those actions or transactions, we'll just continue keep doing it, irrespective of the harm it does. So from a philosophical standpoint, my lord, we know that's wrong, we know it's fraud, but from the standpoint of part one, part two of the civil procedure rule, it is in conflict with those rules and it should be dismissed. So that's it. So we've asked for a number of orders, all in keeping with the matters that's been ruled on, and hopefully that you'll be dismissing today, including to give us a final order on the, first of all, my Lord, consolidate all the matters that's related, that's been filed by Capital One on this same issue. And so there's an across-the-board dismissal of all those issues. 2, wasted costs, my Lord, that the attorneys who have represented Capital One should not profit from this ill-advised venture when they knew from day one that any action taken by Capital One in this matter would have been fraudulent. And we say that from knowing factually that John Graham and company and their attorneys knew from day one that the action of Capital One would have been fraudulent and in violation of the court's rules. Yet they pushed it and continue to push it, even now here, maintaining and talking about some fraudulent action that took place in Florida. They're still here maintaining that status when they know it was misinformation and fraud. So and at great cost to the defendants, they continued the action here and made commitments to Capital One that they know no intelligent person was going to sit around and allow anybody to come in and just stand up in front of them and rob them blindly and then figure that's it. It's not going to happen. And it can't happen because it's a matter of law that they should be sanctioned for breaking the law. Now, Mr. Graham knew about this matter and the actions of Capital being fraudulent. Why, my Lord? Because I met with Mr. Graham and we discussed the matter before he even took the case from Capital One, because when I was served with the document, one of the first attorneys that I was introduced to deal with the matter was Mr. Graham. And Mr. Graham knew that any action taken was apart from it being in conflict, because he sat with me, took all my information and documentation. But I categorically showed him at that point that everything Capital One and he filed in these matters weren't so. So we're deserving of them being held liable for wasted cost, my Lord, and we ask the court to make sure that in terms of the cost that the registrar sets at a very early date, 15 days from now, my Lord, for the cost to be dealt with if Capital One isn't willing to pay the cost that we are asking for. And we're asking for, in terms of cost, at least $3 million US, my Lord, for cost. And that should be paid within 15 days. And if it's to be disputed, then we ask the Lord to instruct the lower court, the tribunal, the registrar, to set the matter for no more than 15 days after the expiration of for the payment of the cost. We ask the court for a final order, and if my Lord notices, or we have attached an affidavit with a U.S. court of Fairfax County, the requirements that the court demands for a final judgment from a foreign country to be recognized. And that final order must state, this is a final order for X amount of dollars against which Capital One must pay to X parties, and Anthony Thorpe, my Lord, is the party that's to be designated. And alternatively, all the damaged parties, all the parties that were damaged by Capital One are subject to the undertaking given by Capital One as another rule. And 2 Lord, a permanent injunction against Capital One or any related entity owned by Capital One from refiling the same issue, and that injunction should include to no longer interfere with the defendant's businesses. We also ask for interim payments if Capital One decides they aren't going to pay the $2 trillion in damages, that the court grants an order for interim payments that must be met by a specific date, and if not met, Capital One is barred from making any other pleadings in this matter. And so that the claimant will never be made whole again, my lord. That's 17 years of a person's life, health, and the things that could have been achieved during that period, probably won't be able to do it because of circumstances which are on record, and I probably won't need to get into, but the fact is 17 years of a person's life has been negatively affected, and that's one of the fundamental grounds for an appeal of Justice Vaughn Smith's orders. My Lord, how could any judge look at a matter where a person's life has been interfered with and business has been interfered with, literally stopped for 17 years, and then to say no damage was done? Thank you.